This is Headnotes, a podcast from Whitehead Monckton. Coming up on this episode.
So today we're going to be looking at surrogacy under English law.
The law is widely recognised now to not be fit for purpose. The process that most intended parents have to go through is a parental order process. So in most of these cases, these are just loving parents who want to have a child. Yeah. And if they could conceive naturally, then there would be no scrutiny of that kind.
Yeah. Going back to the law reforms that are looking at surrogacy, I think for someone like myself, who does work within the fertility industry at supporting parents. I think for people looking at this path, it's just trying to navigate some of their options. And then I think that the talk of the law reform as well, it almost needs to have happened yesterday, doesn't it? I think we're still waiting, and it's just frustrating.
There is surrogacy law out there at the moment. It is workable. It's not perfect, but there are hopefully changes on the horizon.
Hello, everybody. This is Whitehead Monckton's Headnotes Podcast with Judith and Daniel at Whitehead Monckton. And we have some special guests to talk about surrogacy law today.
Good morning. I'm a senior family lawyer in our Canterbury team. We are joined by Hayley King, who is the head of operations from Path to Parenthood, who is a donor-conceived child and a parent to donor-conceived children. So she's with us to bring her experience and knowledge from this aspect, which is very relevant to surrogacy. And we also have Lara Izzard-Hobbs from 36 Family Chambers in London. And Lara advises on family law, including surrogacy arrangements.
Yes, I wonder if we could start today by asking Lara and Hayley about their experience of surrogacy law. Perhaps, Lara, you'd like to start?
Yes, so my first experience of surrogacy law was when I worked for the pastoral charity Donor Conception Network before I became a barrister, and that gave me a real insight into the experiences of intended parents, also the views and experiences of donor-conceived people, and what the law needed to do in order to work for them. And of course, that's been an ongoing discussion, as we'll come on to. The law is widely recognised now to not be fit for purpose. And we've had recommendations in that respect, but we're still waiting for any progress in terms of implementing them. At the bar, I've also acted in surrogacy cases, undertaken training, and I've been on some advisory panels in respect of surrogacy and donor conception work. And I think one of the things that Hayley will speak to is that interaction between surrogacy, which is often the headline, and also the other elements within it, both pastorally and legally, including donor conception.
Yeah, thank you. Hayley?
Thank you. Thanks for inviting me firstly onto your wonderful new podcast. So I'm Hayley King. I'm head of operations for an organisation called Path to Parenthood. And as Judith explained, I'm a donor-conceived adult. So I was conceived back in the 80s, thanks to donor sperm IVF. But I'm also parenting donor-conceived children with my wife. So we're a two-mum family. And I suppose my first kind of insight into surrogacy was going through fertility treatment. I'm part of the LGBTQ plus community, so I have friends that have gone through surrogacy. But I suppose more formally now through my work on the support platform, we do see lots of intended parents come through that are using surrogacy or looking to potentially go down the surrogacy route, but also donor conception, which is our specialism. And I think similarly to Lara, there's quite a lot of confusion, I think, in this space around surrogacy law. I think we do see the odd headline in the news every now and again. But yeah, I do think there's still quite a lot of confusion out there, and lots of people that are coming through looking at this path are very unsure about where to go for support and sort of really valuable information. So yeah, that's kind of my thoughts in a nutshell, if you like.
That's brilliant. Thank you. Thank you both. So today we're going to be looking at surrogacy under English law, and then also really where things stand now and what the future might look like as well. At the moment, just in a nutshell, we are working from some very old legislation, and it is really kind of 40 years old, that and many people would say that it doesn't really reflect the current situation, also, and it doesn't necessarily support modern families as to the reality of what's happening today for surrogacy and in England and Wales.
So perhaps we can start by dealing with the bullet points, really, about surrogacy law. What are the headlines in relation to surrogacy law, and how does it differ from the way that surrogacy works in other countries? I don't know if you'd like to start, Lara.
So how surrogacy works in other countries is a huge topic. In summary, though, even in countries that are very near us within Europe, the range of legal positions is huge.
Yeah.
In Italy, it's still banned, and indeed it's now become illegal in Italy to even leave to obtain surrogacy arrangements abroad. So there is a huge range of opinion in respect of the ethics of the issues that we're discussing. And that, I think, is definitely one of the points that makes it harder to progress change, even when there is actually quite a broad consensus, particularly in this jurisdiction, about what that change should look like, at least at its core. At the moment, what we have is a situation where the gestational mother, i.e. the person who gives birth to the child, is considered the legal mother of the child, and their husband, even if unrelated to that process, is the legal father. And the process that most intended parents have to go through is a parental order process. That can be quite a long-fangled process. If the arrangements are undertaken abroad, as they often are because of the limitations of the current domestic provisions, then you have to go to the High Court to obtain that order. That requires quite a lot of legal work, quite a lot of potential expense. And it also involves, on any application, a welfare check, a best interests assessment, a scrutiny of the parents. And what I often find in my cases is that intended parents question rightly why they are subject to a level of scrutiny that other people having children are not.
Definitely.
There's a sense that they, after often a long and traumatic period of dealing with infertility struggles, or as an LGBTQ family, questions, inappropriate questions, and feeling somewhat up against it either way, they are then being questioned again. They're being assessed and scrutinised by social workers as if there might be a problem inherently in them. And this is something that's being publicly funded, right? So in most of these cases, these are just loving parents who want to have a child. Yeah. And if they could conceive naturally, then they would do. In inverted commas, then there would be no scrutiny of that kind. Yeah. And so it's entirely understandable that that is a really difficult process. However, there is a reality that surrogacy, in theory, could create potential for exploitation. And that also links us back to the international aspect of it, because there are countries like India, Nepal, etc., where it used to be incredibly common. It used to be a common place to go and obtain much more affordable surrogacy arrangements abroad. And that's since been ended by those countries as a result of concern about exploitation. So there's become an almost international commercial market for surrogacy. And there are understandable concerns about that, but there also have been a lot of benefits. The US, for example, allows considerable detail in terms of arrangements, which it can legitimately be argued protect both the surrogate and the attended parent, and indeed the future child. And some of those sorts of protections and processes, including legal advice for everyone, including counselling, etc., would be the sort of things we would be expecting to see more in this jurisdiction, which is currently seen as, it markets itself, it presents itself as an altruistic jurisdiction. But the issue with that is there isn't a package in the same way.
Sure. Can you explain what you mean by the altruistic element of surrogacy in the UK? And yes.
Yeah, so commercial surrogacy in this country is not allowed. Commercial being providing money for surrogacy services, as far as you can call it that. And you can see immediately why it is a sensitive subject for lots of people when you speak about someone growing a child in their womb and giving birth to them as a service. It's a strange concept for lots of us. But also people who have children through surrogacy, and lots of surrogates would say it's a wonderful process that that they have been hugely fulfilled from. And there are lots of surrogates in this country who choose to do that altruistically. Now, there is, however, a catch, which is, and I don't say that in a pejorative or loaded way, but the reality is that this person is giving up, the surrogate is giving up a huge amount of their time. They're giving up, they're putting their health in a position which it would not otherwise be. And it's entirely understandable that there would be a number of expenses, both career-wise and otherwise, associated with that,
Sure.
and a level of pastoral and emotional support required. And that is the sort of thing that is much more readily contained within a contract, for example, in certain parts of the US that deal with that. And we can and should do better on that, even whether it's in an altruistic context or not. So at the moment here, what's happening is that's known financially as reasonable expenses. And there is a larger topic here in terms of the law being stretched to match the realities. But in terms of reasonable expenses, what that means is almost always whatever expenses are submitted as having been paid to the surrogate are signed off. Yeah. And those have become increasingly generous over time. Okay. And you could query whether those are indeed,
as you say, to match
simply reasonable expenses that fit within that altruistic characterisation. And the subtext is that the judges think the law isn't fit for purpose, and we have high court judges
finding a workaround. Really.
Yes, and it's more arguable, perhaps, in the context of reasonable expenses, you could say, but there are other criteria within the current law that are being stretched to an extent which it is really beyond what anyone can say is a common sense reading of the law. 6 months timescales being interpreted as meaning many, many years, and other such more black and white criteria, which are being read down, i.e. interpreted by High Court judges in a way that clearly isn't
to
what
help the parents.
They're meant. Yeah. And it relies to a certain extent on the fact that no one is going to appeal those judgments because they are considered to be in the best interests of the children and the parents. No one's opposing it.
No.
The opposition is the law itself, which everyone agrees really needs to change. And those things can be changed without the same level of sensitivity in general, without hitting on those key touchstones that are more controversial.
My understanding is that a law commission put forward proposals to change the law in 2023, but nothing's actually happened yet.
Yes, that's entirely right. We're still waiting for this to be processed. We're still seeing invitations for further consultation, despite the fact that that was all undertaken as part of the Law Commission process. And one of the points is that the Law Commission recommendations, while welcomed by most in the family law community who deal with these cases, still do not address all of the scenarios that we're currently seeing. And I think there are lots of people who would say that they don't go far enough.
Yeah.
And we're still waiting a long time for those.
And the recommendations are clearer definitions around the expenses, the permitted expenses, which you could expect, I suppose, to become more akin to how somewhere like America deals with it, I would expect. And then a stronger role for the surrogacy, the non-for-profit surrogacy organisations to take more of a role within the surrogacy for each parents. And then an important point is that to allow or to increase the better information for and access for children as they grow as well. Which I don't know, Hayley, do you have anything to say about that? Because obviously that's something that it's very key, I understand, for donor conceived children, and also for those intended parents who want to be able to obviously support and support their children with their origins and how everything's come about through surrogacy.
Yeah, sure. Well, I mean, many people that are using or going down the route of surrogacy will be using donors too. And I think just listening to Lara talk about the different parts of the world, the things you have to consider, not only obviously if you're looking at a UK pathway, but an overseas pathway, there are so many things to consider. And obviously donation, if that is part of your route to parenthood is something else, again, that you then have to consider, not only for yourselves as parents going through or intended parents going through the process, but what your future child who is conceived via donation and surrogacy some of the information that they may want to know as they get older. And like I say, I know part of with the surrogacy law reforms, they're trying to ensure that those rights of the donor conceived child through surrogacy is protected, which I think is really, really important, because often the voices of those conceived through donation and surrogacy kind of get overlooked sometimes in these conversations. So it's really important to make sure that those needs and concerns are centred. But yeah, I just think I just wanted to sort of, I know as Lara was talking about the different parts of the world, and I know for people that we've supported that have worked with surrogates overseas, sometimes obviously understandably because of that is maybe their priorities, to find somebody that is willing to be a surrogate and support them on their journey. But then if they do need a donor as well, whether eggs or egg and sperm donor to go alongside that to create embryos, they often find maybe they've working with a surrogate overseas and then actually find out that the donor that they may want to use is, say, a fully anonymous donor. And because that child will be conceived outside of the UK regulatory framework, it means that that child can then not access the, say, identifying details of the donor, which would be protected if that same intended parents had gone through a UK pathway. So it's just something I wanted to highlight, really. But I think going back to the law reforms that are looking at surrogacy, I think for someone like myself, who does work within the fertility industry at supporting parents, some of which are through surrogacy, there is so much information to try and take in. And I think there's a lot of confusion. And I think for people looking at this path, it's just trying to navigate some of their options. And then I think that the talk of the law reform as well, it almost needs to have happened yesterday, doesn't it? I think we're still waiting, and it's just frustrating, I think, that it's taken so long. And we're seeing a similar thing with donor conception law reform as well. The HFEA launched their own public consultation a number of years ago, actually, and suggested a number of law reforms, again, for donor conception related law. Obviously, the HFEA don't make the laws. They can just regulate them. But we're very far behind, even in the UK, with our donor conception related law practices as well as surrogacy, sadly.
And I don't know if you agree, but that does mean that the way that the British system works at the moment means that it does make it extremely difficult for intended parents to navigate the surrogacy world.
Yeah, I mean, from my experience, I mean, I have many colleagues that work and support parents more specifically within surrogacy, and they obviously explain that many intended parents will look to pathways overseas because they find it too difficult in the UK. There's maybe too many restrictions. There's some great charities and organisations here and the non-profits that you mentioned that work really hard to try and support parents in their home country here in the UK. But often, like you say, there's too many restrictions. Like I say, that hopefully will change and make it kind of an easier process for parents or intended parents. But at the moment, we're still being told that there's lots of restrictions in place.
And we've got no idea of when these law reforms will be properly considered, which is the difficulty. And I suppose whilst the situation is not particularly helpful, looking at some of the, even the European countries where surrogacy is banned, or there's very strong restrictions on it, then in that way, and they're the countries that you would perhaps think would be supportive of surrogacy. So we're lucky in that regard that it's actually permitted here.
Yes.
You've mentioned obviously Italy, but there's other European countries as well, which comes as a little bit of a surprise that they simply don't allow it. In terms of, I suppose, whilst we don't have the any kind of change in the law at the moment, are there any practical tips that you would offer, or you'd like to offer to intended parents that might support them through their journey if they're just thinking about or contemplating about going through surrogacy and using donor eggs or sperm? Is there anything that you would that you can think of that would be practical for them to start out, I suppose, at the beginning of their journey that would be helpful to know, or helpful for them to, whether it's kind of areas of support or who they should be speaking with? Any practical tips?
I think it's just actually trying to educate yourselves a little bit. Like, I suppose if anyone's listening to this podcast, that's the kind of thing that I would 100% recommend, listening to the people that work in this area and have a lot of knowledge that can pass on to, because you don't know what you don't know. It's such a cliche, but it is so true. And I think just speaking from a donor conception point of view, and if you're looking at using donors, there's you can obviously get support from a clinic, but actually some of that support only goes so far. And a thing that we haven't really touched on, I suppose, today is the emotional complexities of using surrogacy and donor conception, and the fact that some people may have come to this path not expecting to, maybe through infertility, or even if it is a path that you were expecting all along, it is something that will raise a lot of fears and anxiety. So a lot of that my advice would be to seek support from support organisations. So I know Lara mentioned before we came on, used to do some work for the Donor Conception Network. They're a great organisation. The network and the organisation I work for, Paths to Parenthood, we do a lot of work with parents and intended parents through donor conception. And then there's also lots of surrogacy, like I say, non-profits out there. The ones that I know quite well are Surrogacy UK and My Surrogacy Journey, and they've got lots of free advice online, their own podcasts. So definitely just try and absorb some information, but also equally try not to get too overwhelmed by it, because you can end up having all of this info and not really knowing what to do with it all. So just try and take on some information as best you can, and talk to others that have actually gone through the process as well. That would be my top advice.
That's brilliant. Thank you. And Lara, have you got anything to add?
Well, just in terms of the Law Commission proposals, just going back to that, I mean, the main thing it will do is allow for parents to become legal parents, rather than the surrogate being the legal mother and her husband being the legal father as described before. It will allow for the intended parents to be recognised as the legal parents from birth,
start,
without having to go through the application process that I was describing. And that's obviously subject to certain requirements, but that allows certainty for the child from birth in terms of their identity. It means that they're more protected from potential errors in not understanding the system. And that's the thing. What Hayley's talking about is, if you make the system impenetrable, there's a real risk, particularly when legal advice is so expensive, that with the best intentions, particularly when people have been through a difficult time, things are missed. And when you have a system that is tick box orientated rather than holistic and is very technical and complicated, then that puts children at risk of being left in limbo of some kind. And there are also, I don't think we'll get onto it today, but there are also immigration implications if they're international. There are so many opportunities for technicalities to be missed that could leave children in limbo. And that, of course, is not in their best interest. And that's always the overriding concern in any children case in the family courts.
And it does seem like there are a huge number of law reports out there, cases that have come to court, where judges have been willing to bend the law considerably because of these lacunae and these gaps in the system, which cause so many problems for parents and children.
And they use the overarching test of paramountcy of the best interests of the child in order to do that, which is a fundamental, very familiar concept to children's specialist family lawyers. But again, there's a difference. If you're having a child via this route, there are all these quite rigid and seemingly quite outdated criteria that are also technically required to be met. Whereas if you're dealing with a child in any other family court case involving children, you pretty much just have to look at the holistic assessment of what's in the best interest of that child. So that's really what the law is trying to keep up with. But one of the intentions of the proposals is to make the domestic arrangements more attractive to people, to make it simpler, to make it more accessible, to make it more caring for the people going through that process and for the children coming out of the other side. And with the intention, in part, of discouraging the complications of the international surrogacy arrangement, but also there's a sense that this country still takes the view that commercial surrogacy is not the way forward.
So is there a sort of sense that there's a desire to make it, I'm not looking for the right word here, more transparent, less clandestine? it seems like quite an odd situation currently.
But while retaining some of the characteristics that actually essence. Most of the parents I represent in the High Court, they've gone to the US to get a much more transparent process than they would get under these revised arrangements.
So they feel like they have more certainty.
So what these proposals are trying to achieve is to give enough in that direction that keeps people in this jurisdiction, which is partly a differing view of what the right way to do surrogacy is, which people might disagree on, but also I think on some fronts is just basic common sense and unavoidable. And one of the impacts of that, linking back to what Hayley said, just to clarify from a legal perspective, is that there are imperfect but relatively clear rules on sharing information with donor conceived people here, certainly compared to some other countries. And if you engage in donor conception, as often happens alongside surrogacy here, then that child will automatically have access to information about their parents, at least in the terms that are currently provided for in law here, which is not guaranteed if you go to a different country. And as Hayley said, there are often parents who choose to go abroad not thinking about that aspect of it because it's one of so many aspects, and sometimes donor conception and surrogacy are dealt with separately, and there are lots of lawyers who know a lot about surrogacy and the technical application process, but partly because they haven't worked with people like Hayley, worked in the organisation I worked with coming through, then they're not thinking about the long-term implications for children of not knowing what their heritage was.
Yes, exactly. The human aspect.
It wasn't that long ago that we had cases where judges were saying, actually, who brings you into this world is not what matters, where doctors were advising intended parents in donor conception cases not to tell their children that they were donor conceived.
Where it's actually, as part of the witness statement for the application for the court for the parental order, a key part of it is, or one element of it is explaining to the judge how you intend to tell the child how about their origins and how they came to be, and that's a really important part of the journey for the intended parents, but also the court recognises the importance for the child as well, so that they are told at an early stage and are supported with how they were created and how they came to become a family through surrogacy. It supports that.
Yeah, I was going to say, Judith, is somebody who was conceived via donation but wasn't told. So my parents were the generation where they were advised to keep it a secret and that kind of thing. And obviously I found out very late in life, and that's how I actually got into this area, if you like, talking about my story and the advocacy involved. And interestingly, that when you combine surrogacy with donor conception, there's been some recent research, Damore in 2005, actually this year, that looked at the experience of fathers, gay fathers through surrogacy. And when you're talking about the donor conceived child, one of the points of that research and looking at their experiences is that they actually saw the narrative of talking to their child about the surrogate and the donor or donors very differently. So the donors were very abstract. They found it very difficult to bring those conversations up, weren't really sure at what age to do that, whereas obviously with the surrogate, especially if they had a lot of contact through the pregnancy and beyond, they found that process very easy. And that's another example where surrogacy and donor conception often are very intertwined by the nature of the process, but actually are dealt with very differently emotionally, psychologically. And it's just something that I'm very interested in, I suppose, as someone who wasn't told. And I often, is a big passion of mine is making sure that parents are fully supported in talking to their children from a very young age, because we do know that's in the best interest of the child, not only for them, but also for the family long term. But it's interesting that even a very recent research paper into families built through surrogacy kind of distinguish those narratives between the surrogacy and the donor conception. So,
Thank you.
I've had clients say to me before along those same lines. I've had an intended parent mother say to me before, she found it much easier emotionally to accept the role of the surrogate than she did to accept the role of the egg donor. And she absolutely wasn't saying, I oppose this child knowing about their identity, or I'm going to pretend this hasn't happened. But as we've already both touched on, Hayley, we're talking about people who've been through a really, really difficult time. Sometimes, particularly if they're a heterosexual couple, envisaged being able to have a child in a different way that wouldn't have involved all of these complications. And they've gone through effectively a grieving process of realising that's not going to be possible. And then the idea that they thought this child would have a piece of them as such in a genetic sense is quite difficult to process, on top of all of these technical, legal, financial, practical associations, whereas someone carrying their child feels a little bit more, a little bit easier to accept, was my experience as well. Even, and I am absolutely not criticising anyone for this. This is a really difficult process for anyone. It's really emotional, and that's why it has to be dealt with in a really sensitive way.
And that's probably why it doesn't really fit naturally into any kind of legal process. I mean, the legal aspect of it is minimal. It's a whole holistic viewpoint, isn't it? That has to take into account so many different emotions and so many different life experiences. It's so curious, unlike almost every other aspect of family law, which naturally more fit into laws and regulations. This seems to be something that can't be contained by it. It is...
Well, although all families are different, and we see cases, every single child arrangements case I see is different, but the judge has a very flexible family law concept, the best interest of the child. And as we see in these bending of the law cases in the High Court, they use that very concept in order to bend the principles, which are, the child must be carried by a woman who's not one of the applicants. They must be married, must be made within 6 months of the application. The child's home must be with the applicants. What happens if they're separated, but they have a good relationship? We deal with separated parents cases all the time. Either or both of the applicants must be domiciled in the UK. What happens if one of them moves? And we have those cases all the time. And the courts have no difficulty dealing with them. Well, they might have difficulty dealing with them, but their difficulty isn't that the law is too rigid. They've got family law flex principles that allow them to undertake that holistic assessment. And indeed, the case law says consistently it is a holistic assessment. It says that even if we're talking about a care case removing a child, it's about the best interest of the child and holistically assessing that. And that's ultimately that same process in the judge's mind that they're used to, that they're applying in these cases, but they're doing so against the tide of the also HFEA. One of the confusing areas in this is we have two acronyms that refer to two different things, one being a legal act and one being the Human Fertility and Embryology Authority rather than the Act. So that's just a tip and a trick for anyone who's an intended parent trying to navigate Google on these issues.
Well, that's brilliant. Thank you ever so much for both of your insight and input today. I think it's been incredibly valuable, hopefully for our listeners, and certainly for Daniel and myself as well.
Yes, thank you to both of you.
And I think the key point is that there is surrogacy law out there at the moment. It is workable. It's not perfect, but there are hopefully changes on the horizon, but just no one can say when.
But also, it's incredibly heartening to think that there are so many support networks and
absolutely,
and organisations out there that, as Hayley has said, can provide invaluable information for people who are trying to navigate this area.
And there is a huge support for these reforms going through as well. There are a lot of people involved in trying to push this through. So hopefully there will be some
Let's
more
hope
positive...
they succeed soon, and we, as Lara said, that we have something workable and flexible to take into account all of the different ways in which people need help.
And in summary, I suppose that for any listeners, the key point is to get early advice. So support from various organisations, build a support network, seek early legal advice, and that's pretty much key, isn't it, to hold you in good stead for what will hopefully be. Most of the journeys are very smooth through surrogacy, so it should be a wonderful journey once you've jumped a few hoops to get there.
Fabulous. Thank you very much.